The Supreme Court of the United States has taken a step no court has taken in the 249-year life of the American Republic. It informed a sitting president that he does not possess the authority to levy taxes. The authority to impose tariffs rests with Congress, just as it has since the era before the Constitution was ratified. On February 20th, 2026, 6 justices, including 2 nominated by Donald Trump, concluded that the president lacked legal grounds for his broad global tariff program, finding that the emergency statute he invoked did not confer that power. When the news reached him during a meeting with governors, the president dismissed the ruling as a disgrace. The moment signaled a direct institutional confrontation over the boundaries of executive power. Within hours, the president described the justices who ruled against him as unpatriotic and disloyal to the Constitution, and called them an embarrassment to their families, singling out his own nominees, Neil Gorsuch and Amy Coney Barrett. Before the day was over, he signed a new executive order establishing a 10% global tariff under a different statute that carries a 15% ceiling and a 150-day limit. A close reading of Chief Justice John Roberts' opinion, alongside Warren Buffett's reaction, makes clear that this dispute extends far beyond trade policy. It marks a defining constitutional episode about the outer limits of presidential authority. The clash unfolded not in abstract theory, but in the mechanics of economic governance. The case, Learning Resources Incorporated vs. Trump, centered on businesses contesting the president's claim that the International Emergency Economic Powers Act of 1977 authorized him to impose tariffs. Although that law permits presidents to regulate economic transactions during declared national emergencies, no president in its half-century of existence had ever relied on it to create tariffs. Chief Justice Roberts methodically rejected the argument that the power to regulate importation necessarily includes the power to tax. He observed that the statute contains no reference to tariffs, duties, or taxes. The absence of those words, he suggested, was not an oversight, but a limit. Roberts stressed that regulatory authority does not automatically carry taxing authority, and while Congress has delegated tariff powers in the past, it has done so with explicit boundaries and procedural safeguards that this statute lacks. Pointing to Article 1, Section 8, he reaffirmed that the power to lay and collect taxes belongs solely to Congress. He made clear that the court's function is not to weigh economic strategy, but to enforce the Constitution and the lines it draws. The decision echoes the 1952 ruling that blocked President Truman from seizing steel mills during wartime. In both instances, the court underscored that urgency does not erase constitutional constraints. The majority warned that the president's reading of the law would permit a dizzying range of unilateral adjustments, a description that mirrored the turbulence of the previous 13 months when tariff policies shifted frequently through social media announcements. Invoking the major questions doctrine, the court held that Congress must speak clearly when granting such sweeping economic authority. Justices Gorsuch and Barrett joined the majority, while Justices Thomas, Alito, and Kavanaugh dissented in the 6-3 decision. The ruling voids billions of dollars in tariffs imposed under that emergency statute, though it leaves untouched tariffs enacted under other laws such as Section 232 or Section 301. The practical consequences are immediate, even as the legal debate continues. Economists estimate that more than $175 billion was collected under the emergency law, costs borne largely by American importers and consumers rather than foreign governments. Small businesses described the constantly shifting tariff landscape as destabilizing and, in many cases, ruinous. The court's opinion leaned on a foundational principle of the American experiment, that taxation must be tied to representation. The framers placed the taxing power in Article 1 precisely to prevent it from resting in the hands of a single individual. James Madison and his contemporaries understood that the authority to tax carries the capacity to destroy. Historically, tariff authority originated in Congress, and although lawmakers have at times delegated portions of that power to the executive branch, those delegations have been carefully confined. The president's reliance on the emergency statute bypassed many of those guardrails, enabling unilateral decisions that reshaped sectors of the economy. In the wake of the ruling, he turned to Section 122 of the Trade Act of 1974, which imposes a 15% cap and a 150-day duration on such measures. That timetable means the new tariffs would lapse shortly before the 2026 midterm elections unless extended through legislative action. Whether the $175 billion already collected will be refunded is likely to be resolved in future court battles. During the State of the Union address, the strain between the executive branch and the justices was evident to observers in the chamber. The president's swift pivot to a different statute to sustain tariffs raises a broader question about whether constitutional limits are viewed as binding guardrails or hurdles to navigate around. Warren Buffett remarked that financial markets struggle to price the absence of clear rules, and he framed the ruling as a restoration of the constitutional order in which Congress writes tax law. He suggested that prolonged unpredictability resembles autocracy cloaked in economic terminology, and that the harm from such instability can exceed the damage of flawed policy. His comments underscored how constitutional structure and market confidence are closely linked. Buffett also took issue with the president's criticism of his own appointees, noting that judges are sworn to apply the law rather than serve the interests of the officials who nominated them. The decision illustrates the judiciary's capacity to check executive expansion when Congress does not intervene. For 13 months, businesses operated under shifting directives that many regarded as arbitrary. But the Supreme Court has now declared that the emergency statute cannot serve as a vehicle for tariffs. Significant legal and economic questions remain unresolved, yet the center of gravity for tariff policy has been returned to the legislative branch. In doing so, the ruling reinforces a system in which voters can hold their elected representatives accountable for decisions on taxation and trade. In the days that followed, legal scholars across the ideological spectrum described the ruling as a reaffirmation of structural constitutional principles rather than a partisan rebuke. Former clerks to the court noted that the opinion was written in restrained language, careful to ground its reasoning in text and precedent instead of rhetoric. That restraint, however, did little to soften the political reverberations in Washington. Lawmakers who had largely deferred to the executive branch on trade policy were suddenly confronted with the reality that silence does not substitute for statutory clarity. The decision placed Congress back at the center of a debate it had, for years, allowed the White House to dominate. Behind closed doors, business leaders began recalculating investment plans that had been frozen amid months of volatility. Manufacturers who had shifted supply chains in response to abrupt tariff announcements now faced the prospect of another adjustment if courts ordered refunds or if Congress moved to codify new trade measures. Trade lawyers warned clients that even with the court's ruling, uncertainty would persist as litigation over past collections wound its way through lower courts. Markets responded not with dramatic swings, but with cautious recalibration, reflecting relief that constitutional boundaries had been clarified even if policy outcomes remained unsettled. The broader signal was that the rulebook, though tested, had not been discarded. Within the executive branch, advisors debated how aggressively to press the alternative statutory authority now being used to sustain tariffs. Section 122 offers temporary leverage, but its built-in expiration forces a return to Congress unless lawmakers act. That dynamic introduces political risk, particularly in an election cycle when trade policy can shift from a technical matter to a campaign issue. Some administration officials argued that the court's decision narrowed tactical options, while others viewed it as an opportunity to pursue a more durable legislative framework. Either way, the ruling altered the balance of negotiation between the branches. On Capitol Hill, committee chairs began discussing hearings that would examine not only the economic effects of the tariffs, but the broader question of delegated power. Members who had long criticized expansive executive action in other contexts found themselves weighing consistency against immediate political advantage. The constitutional design assumes that ambition will counteract ambition. Yet, in modern governance, that friction is often muted by partisan alignment. The court's intervention disrupted that alignment, at least temporarily, by forcing legislators to decide whether to reclaim authority or continue relying on emergency statutes. The answer will shape not only trade policy, but the architecture of executive power in future crises. For voters, the implications are less abstract than they may appear in legal briefs. Tariffs influence prices at the register, costs in supply contracts, and the competitiveness of domestic industries. When the power to impose those costs shifts from unilateral executive action to congressional debate, the process becomes slower and more visible. That visibility can generate accountability, but it can also expose divisions that had previously been managed behind closed doors. As the midterms approach, candidates will be pressed to articulate where they stand on both trade and the proper scope of presidential authority. The Supreme Court's decision does not resolve the economic argument over protectionism versus free trade, nor does it predetermine how Congress will respond. What it does is reassert a constitutional baseline that had blurred under the weight of emergency declarations. By insisting that taxation requires clear legislative authorization, the court restored a line that traces back to the founding generation. Whether that line remains bright will depend less on judicial opinion than on political will. The coming months will test whether the other branches accept the limits described in the opinion or seek new pathways around them. That test may unfold first in the lower courts, where businesses are preparing claims seeking reimbursement for tariffs already paid. Judges will have to determine not only whether refunds are warranted, but how to administer them without creating further disruption in global supply chains. The mechanics of repayment could prove as complex as the original collections, involving customs records, contract adjustments, and layered liability across distributors and retailers. Treasury officials are likely to argue for caution, emphasizing fiscal stability and orderly process. Plaintiffs, by contrast, will frame the issue as a straightforward matter of constitutional compliance and equitable relief. At the same time, foreign governments are watching closely, recalibrating their own trade strategies in response to the court's decision. Diplomatic channels that had grown tense under shifting tariff announcements may reopen with a different tone, as negotiators reassess what commitments are sustainable under domestic law. Allies who questioned the durability of executive agreements now see clearer evidence that congressional involvement is indispensable for long-term policy. That reality could complicate short-term bargaining but strengthen credibility over time. Stability in constitutional process often translates into stability in international expectations. Inside the administration, the language surrounding trade has begun to shift in subtle ways. Public statements emphasize statutory authority and congressional partnership more than unilateral resolve. Advisors are mindful that future emergency declarations, whether economic or otherwise, will face heightened scrutiny from courts attuned to the major questions doctrine. The precedent now stands as a caution against expansive readings of broadly worded laws. Even if new strategies are pursued, they will likely be framed with closer attention to textual grounding. The political dimension remains fluid as lawmakers weigh how prominently to feature the ruling in campaign messaging. Some candidates portray it as a necessary recalibration of constitutional balance, while others describe it as judicial intrusion into economic policy. Voters, meanwhile, are more likely to measure outcomes than theories, focusing on prices, jobs, and the steadiness of markets. If Congress moves to draft clearer tariff legislation, the debate will unfold in committee hearings and floor speeches rather than executive announcements. That shift alone alters the rhythm of policymaking and the distribution of accountability. Beyond trade, the decision may influence how future presidents approach emergency powers across a range of issues. The court signaled that sweeping authority requires unmistakable legislative endorsement, a principle that could resonate in disputes over technology, energy, or national security. Executive lawyers will study the opinion line by line, searching for guidance on where regulation ends and taxation begins. Lawmakers may respond by drafting statutes with sharper definitions, anticipating judicial review before controversies arise. In that sense, the ruling operates not only as a boundary, but as an invitation to greater precision in governance. As the branches adjust, the broader public conversation continues to evolve. Commentators on both sides acknowledge that constitutional structure can feel distant until it intersects with daily economic life. When it does, abstract clauses take on tangible meaning. The allocation of taxing power is no longer confined to textbooks or courtroom arguments. It shapes invoices, paychecks, and investment decisions. The unfolding response from Congress and the executive branch will determine whether this moment becomes a brief correction or a lasting recalibration of authority. In constitutional law, seminars, and policy forums, the ruling is already being treated as a case study in the modern presidency. Professors point to the steady expansion of executive action over the past several decades, often driven less by ideology than by congressional inertia. When lawmakers decline to legislate in detail, presidents of both parties tend to fill the vacuum with aggressive interpretations of existing statutes. The court's opinion interrupts that pattern by insisting that silence cannot be converted into sweeping fiscal authority. It sends a signal that broad language in emergency laws will not automatically stretch to cover powers traditionally reserved to Congress. That signal carries implications for how future administrations draft their internal legal justifications. Office of Legal Counsel memoranda, once shielded from public view, may now be written with an eye toward eventual judicial scrutiny. The reasoning that supports emergency action will likely grow more cautious, more text-bound, and more attentive to historical practice. Lawyers advising the executive branch must now account for a majority that appears willing to enforce structural limits even in politically charged contexts. The message is not that emergencies are irrelevant, but that they do not dissolve the separation of powers. For Congress, the decision presents both an opportunity and a burden. Reclaiming tariff authority requires legislators to confront difficult trade-offs that unilateral action once allowed them to avoid. Debates over supply chains, domestic manufacturing, and consumer prices will have to be hashed out in open hearings rather than announced through executive directives. That transparency may sharpen disagreements within parties as much as between them. Yet it also restores a deliberative process that the Constitution envisioned when assigning the taxing power to the legislative branch. The business community is adjusting its expectations accordingly. Companies that once monitored social media feeds for policy changes are now redirecting attention to committee calendars and draft bills. Lobbyists are preparing for a more traditional cycle of negotiation, amendment, and compromise. That process may be slower, but it offers a different kind of predictability rooted in procedure rather than personality. Markets tend to favor clarity, even when the outcomes are contested. International partners are likely to adapt as well, recalibrating their strategies to engage not only with the White House, but with key members of Congress. Trade negotiations could become more layered, reflecting the need for legislative endorsement of durable agreements. Foreign officials who once viewed executive proclamations as definitive may now factor in the possibility of judicial review. This recalibration does not eliminate friction, but it aligns diplomatic expectations with constitutional realities. Over time, that alignment can shape the credibility of American commitments abroad. As the next election cycle intensifies, the constitutional debate will intersect with campaign narratives about economic stewardship and institutional trust. Candidates will be asked whether they support stronger congressional control over tariffs or broader executive discretion in times of economic strain. Voters may not parse statutory language, but they will respond to arguments about accountability and stability. The court's decision has shifted the terrain on which those arguments unfold. What remains uncertain is how enduring that shift will prove, once the pressures of governance resume their familiar force. In the weeks ahead, attention will turn to how narrowly or broadly lower courts interpret the Supreme Court's reasoning. Some judges may confine the ruling strictly to the emergency statute at issue, while others could read it as a broader warning against creative expansions of delegated authority. That distinction will matter for future disputes involving sanctions, export controls, and other tools often justified under emergency powers. Each new case will test whether the principle announced here remains tethered to tariffs or radiates outward into adjacent areas of economic policy. The judiciary, once reluctant to second-guess executive claims of urgency, now appears more prepared to draw firm lines. Within Congress, staff are quietly revisiting older trade statutes that were drafted in different political eras. Many of those laws contain language shaped by Cold War anxieties or late 20th century economic assumptions. Lawmakers must decide whether to modernize them with clearer definitions and guardrails, or preserve ambiguity that grants flexibility in uncertain times. The temptation to leave broad discretion intact will compete with the recognition that courts may no longer tolerate sweeping interpretations. Legislative drafting, often overlooked by the public, has suddenly become a central arena for constitutional calibration. The executive branch, for its part, is likely to refine its public messaging about the balance between decisiveness and legality. Future announcements may emphasize consultation with congressional leaders before major economic moves are unveiled. That shift would not necessarily reduce policy ambition, but it could alter the optics of how decisions are made. A president who seeks statutory backing before acting may appear constrained. Yet that constraint can also function as institutional insurance against judicial reversal. In a system built on separated powers, process can be as consequential as outcome. Business associations and industry groups are adjusting their advocacy strategies to this new environment. Rather than concentrating pressure solely on the White House, they are expanding outreach to committee chairs and ranking members. The calculus now includes the likelihood that durable tariff regimes will require bipartisan legislative support. That reality may temper abrupt shifts in policy, but also complicate efforts to move quickly in response to global developments. The private sector's adaptation underscores how constitutional structure shapes economic behavior in subtle but persistent ways. Public opinion will continue to evolve as the practical effects of the ruling become clearer. If prices stabilize and trade flows regain predictability, the decision may be viewed as a stabilizing force. If, instead, policy gridlock delays action during economic strain, critics will argue that the court has constrained necessary flexibility. These competing narratives will play out across cable panels, campaign rallies, and editorial pages. Beneath the noise, however, the central question remains consistent with the one that animated the framers. Who holds the authority to impose costs on the public, and under what conditions? The answer, at least for now, rests where the Constitution placed it. Congress must decide whether to exercise that authority directly, delegate it with precision, or refrain from sweeping action altogether. The President retains significant tools, but they are bounded by statutory text and judicial interpretation. The Court has clarified the framework without dictating the policy path. How the elected branches respond will determine whether this episode stands as an isolated correction or the beginning of a more sustained rebalancing of power. Even as the institutional response unfolds, the ruling has begun to shape conversations about the nature of emergency itself. Over the past 2 decades, presidents of both parties have increasingly relied on formal emergency declarations to unlock statutory authorities that would otherwise remain dormant. The Court's insistence on textual clarity signals that declaring an emergency does not automatically expand the substance of executive power. That distinction may influence how future administrations frame crises, whether economic, technological, or geopolitical. The threshold for invoking extraordinary authority may remain political, but the scope of that authority is now subject to sharper judicial review. Legal historians note that moments like this tend to ripple outward over time rather than produce immediate transformation. The steel seizure case in the mid-20th century did not end executive ambition, yet it provided a durable citation point for decades of litigation. This tariff ruling could serve a similar function, offering lower courts a structured analysis when confronted with expansive readings of broad statutes. Lawyers challenging executive action will likely anchor their arguments in the same separation of powers principles articulated here. In that sense, the opinion becomes part of the constitutional vocabulary available to both branches and litigants. Inside federal agencies, career officials are recalibrating internal procedures to account for heightened scrutiny. Regulatory proposals that intersect with taxation or trade may undergo more rigorous legal vetting before they are finalized. Risk assessments now include not only economic and diplomatic consequences, but the probability of judicial invalidation. That layer of caution can slow decision-making, yet it also reinforces institutional discipline. Over time, such discipline may produce policies that are narrower but more resilient. The political incentives surrounding delegation remain complicated. Members of Congress often prefer broad statutes that grant flexibility while diffusing accountability. Presidents, faced with immediate pressures, are inclined to test the outer boundaries of those statutes. The Court's decision interrupts that tacit arrangement by reminding both branches that ambiguity carries legal risk. If lawmakers respond by drafting clearer limits, the space for unilateral reinterpretation may narrow. If they choose instead to preserve flexibility, future clashes with the judiciary are almost inevitable. For the public, much of this debate unfolds at a distance, filtered through headlines and campaign messaging. Yet the consequences surface in tangible ways, from the cost of imported goods to the stability of investment decisions. When authority is exercised through transparent legislative debate, the process may appear cumbersome, but it offers visible channels for input and dissent. When authority is concentrated in executive directives, action may be swift, but subject to abrupt reversal. The Court has not resolved which approach produces better economic outcomes, but it has clarified who must ultimately decide. As the midterm elections draw closer, candidates will likely be pressed to articulate how they would navigate the balance between agility and constitutional restraint. Some will argue that modern economic competition demands rapid executive action, while others will emphasize the safeguards embedded in legislative deliberation. The ruling ensures that this debate cannot be avoided or relegated to technical committees. It places the structure of governance itself on the ballot alongside policy preferences. In doing so, It reinforces the idea that constitutional design is not a background detail, but an active force in contemporary political life.